All right. It looks like we are live. What is going on, BRI-HIVE? How is your Thursday going? This week has went by so fast. Really, every week goes by so fast. Go ahead, if you're watching live, drop in the chat how your week has been. Let me know how your day has been. Has it been long? Has it been short? Whatever you want to let me know in the chat. If you're watching on the replay, go ahead and comment. How has your week been? It is already Thursday. I cannot believe how fast time goes. For those of you who do not know me, I am Boss Attorney Bri, and I am a licensed California attorney where I practice family law and trademark law. And here over on the BRI-HIVE, we cover celebrity lawsuits, trademark lawsuits, copyright lawsuits, and really whatever we feel like covering that we think will be interesting. And today we have two cases that are pretty interesting. Both, I guess you can consider them celebrity cases. One is about a festival. Another is about actually celebrities suing over money that is owed to them. So we're going to be talking about some pretty hot topics, I guess you would want to say. So if you don't understand what's going on my thumbnail, basically Coachella had sued Live Nation and some other people for basically trying to put on a different Coachella that wasn't actually by Coachella. And so we're going to go over that. And it's a trademark infringement because they were using the name Coachella, which they have a trademark for, right? And then we're going to go over a case for Triller, which is supposedly, I've never seen the app, but it's supposed to be a competitor for TikTok. So short form videos. The owners that sold the platform to Triller, they are suing them for non-payment, so breach of contract. And those owners just happen to be Timbaland and Swiss Beats, who are producers and I guess you can say R&B world, rap world. They're producers and they own the original version, which I think was called Versus. So they are suing for like millions and millions of dollars. A lot of articles are saying $28 million, but after reading the complaint, it's like some more millions, like some hundred of millions of dollars. So we are going to get into those cases, but let me know how you guys are doing. I don't see that many chats coming in. Let me know who is here live. We don't have an icebreaker today just because I've been busy. I can't wait to have an assistant help me out with getting all of these things and the research and all of that good stuff. So we got the cases though, and that's what we're going to cover. We're going to cover the cases. All right. We have Alexi Karan saying, yay, another Bri stream. Yay, and welcome back to the live stream, guys. If you are watching live or on the replay and you haven't hit the like button already, go ahead and hit the thumbs up button to help us out in the algorithm so we can get new friends over here at the BRI-HIVE, okay? We have Tanya D, a member and moderator of the channel, saying, hey, Bri and BRI-HIVE, it's been a busy week. It has absolutely been a busy week. It's been a tough week for me, but we're making it through. We're not missing any lives. We're here, and we're going to go ahead and cover some cases. So hopefully the weekend treats you well. Okay, we have Dax is the name saying, hey, here, but at work. Well, we are happy to have you here in the vicinity and happy that you can listen to us while you're at work. We have Crystal Harris saying, hey, hello, welcome to the live stream. And we have Davs Beats, a moderator of the channel, saying, hey, y'all, hey, and welcome back to the live stream. We are happy to have you here. So let me know if you guys actually heard about this case. So remember, the first case is a trademark case where Coachella sued Live Nation. And some other, who else did they sue? Bluehost Inc. and Unified Layer sued them for basically trademark infringement. For those of you who do not know about Live Nation, they're the same company that helped Travis Scott put on that Astroworld concert that ended up in tragedy last year. So they're also being sued for those things. And honestly, I've been seeing a lot of Live Nation lawsuits out there. And Data for Insights actually asked me to cover this case on Tuesday. So I decided to bring it here for today to see if you guys have heard about it, and if you even really care about it, right? Okay, we have my father's son. Welcome back to the live stream saying, hey, Miss Bri, hello to you. We are happy to have you back here. We have Crystal Harris saying, never heard of it. Yeah, I had never heard of it, and it's coming to an end. So we're gonna just kind of go over the complaint, the motion to dismiss, and then we're gonna talk a little bit about settlement, what they probably are looking at with this, but we don't really have any details on the settlement in this case. And now the other case is brand new. It was filed on the 16th, so it was filed on Tuesday, where Timbaland and Swiss Beats is suing Triller for failing to pay them millions and millions of dollars, which is crazy. Sage Moon says, hey, Bri and BRI-HIVE, can't wait to catch and listen to this one. Okay. Yeah, we're going to get right into it. Just doing some introductions. Welcome back to the live stream, Sage Moon. And we have Daz Beat saying, I heard of the Triller suit, haven't heard of the Live Nation one. Oh, wow, really? Okay, because the Live Nation one has actually been going on longer than the Triller one. So they're coming to a close here. And so it was filed in 2021. It was filed in December 2021. So not that old of a case, but at least they are coming to a conclusion. But when you are stealing someone's trademark, you don't want to waste all that money knowing that you stole the trademark. Just pay up and leave. Raina Guzman saying, Law Nerd here. Well, welcome. My first live since I saw you on Emily's live. Well, welcome over to the BRI-HIVE. Yeah, we cover the trademark cases, copyright cases, and we are happy to have you here. So let's go ahead and take a peek at the complaint for the Coachella Trademark lawsuit that is coming to an end within 9 months. That was a quick resolution of the case, to tell you the truth. So let's take a peek here. We have this case filed in the Central District of California, and it is by Coachella Music Festival and the Golden Voice LLC, and it's against Live Nation Entertainment Incorporated, Bluehost Incorporated, and Unified Layer. Not incorporated. Oh, they're doing business. Oh, sorry. Bluehost Inc. is doing business as Unified Layer. Learn how to read, Bri. Okay, and then we're going to go over, this is a complaint for contributory trademark and service mark infringement, contributory false designation of origin, and unfair competition. And so it's interesting that they're actually bringing this case as a contributory infringement case. The reason why that is because it looks like they did not name the main player in the trademark infringement. So they're trying to catch them on the back end saying, hey, you may not have directly been the one trademark infringing, but you helped the big dog trademark infringe. And so we're going to get a little bit into that once we get into the motion to dismiss for the Live Nation side. So here we go. Let's see what we got going on here. What are the facts of the case? We're going to go through that. And since we're doing 2 documents on the case, we're really going to just look at the introduction. And then we're going to look at the motion to dismiss. And then we'll get on to the Timbaland and Swiss Beat case. Okay. Let's see here. We have Deacon Fatal saying, hey, Boss Attorney Bri in chat. Hello and welcome back. Our moderator and member of the channel. Nice to have you here. 2 days, well, not 2 days in a row, but both days of the live stream. A lot of people come both days, but nice to have you here both days. Okay, we have Deacon Fatal also saying, I actually studied up for this one a little bit. Which, for the Coachella one? Okay, because Data for Insights, which is another person that comes to the BRI-HIVE live streams, tweeted me and asked me to cover the case. And so I have time today, so we're going to cover it. So hopefully this is an interesting case for everyone. And then one more, we have Z Seltzer coming in from Cleveland. Hello and welcome back to the live stream. Nice to have you here again, dropping the beautiful BRI-HIVE emojis. Nice to have you here today. Okay. So let's go back to the case. I'm just looking off screen, but I'm looking at the case. We have here, held annually, Plaintiffs Coachella Valley Music and Arts Festival, also known as Coachella, is one of the most critically acclaimed music and art festival in the world. With multiple bands, artists, food vendors, and stages, Coachella is a sold-out event which attracts hundreds of thousands of attendees to the Southern California each April. So they're basically trying to establish that they're popular. People know about them. We are sold out each time. Intentionally trading on the goodwill of plaintiffs' well-known Coachella Festival, the 29 Palms Band of Mission Indians operated a Coachella Crossroad LLC, a corporation organized under 29 Palms Business Ordinance, is attempting to operate a directly competitive live music event that it has named Coachella Day 1 22 at a venue in Southern California that it has named Coachella Crossroads. So they are very, very clearly using the Coachella name. And then they're also having the festival in the same area, which I can see why they're saying this is confusing. We don't want you guys to throw this festival and people think it's an actual Coachella event and it's not up to par. Okay, moving on. They also say plaintiffs have no objection to 29 Palms holding a festival of their own or hosting events at their venue, but it must adopt and use an event name and mark as well as a venue name and mark that avoid a likelihood of consumer confusion and false association with plaintiffs' Coachella Festival and Coachella marks. Despite repeated requests from plaintiffs, 29 Palms has refused to adopt its own distinctive event name or venue name and mark. Okay, so it looks like they're actually having it at like the same area. And you can't do that. They have their trademark. You can't just come along and say, hey, you know what? Coachella is popular and it's a festival, and I'm going to also throw my own festival and call it Coachella. They're not going for that. They have to defend their name, especially with them gaining so much recognition and becoming so popular. You don't want someone making money off of your name, right? Hence why we are here for trademark infringement. Like plaintiffs' Coachella Festival, 29 Palms, Coachella Day 1 2022, festival is advertised as an outdoor live music event that features numerous forms of entertainment and artists and is located in close proximity to the site where Coachella is held. So that makes it even more confusing because they're having it in a similar area. Moreover, 29 Palms has incorporated Day 1 and plaintiffs' well-known and federally registered trademark Coachella in a manner imitative, I guess, and strikingly similar to the way that plaintiff identified their Coachella event using the Coachella mark and weekend 1, weekend 2, day 1, day 2, day 3, and the like. Shown below are representative examples of plaintiffs advertising on the left and 29 Palms advertising on the right. So that completely makes sense. For me, for festivals, and maybe it's because I don't do festivals often, but I don't see having a day 1 and day 2 as super unique. But maybe a weekend 1 and weekend 2 might be a little bit more because I don't know enough about festivals. Do they go on multiple weekends? Festivals, I would assume they go on several days, but as far as several weekends, that one, I don't know. But as far as their marketing and calling it Coachella, yes, in my opinion, they are definitely in the wrong and they are definitely in the right for trying to settle this thing. So on the left, we have the actual Coachella advertisement, and then we have the Coachella Day 1 22 New Year's Eve, I guess. Okay, so branding, I guess there's kind of similar color schemes there. Not all the way. I don't think this was the best example, but it is what it is. This is what they gave us. 29 Psalms has even copied plaintiffs' advertising, promotional, and marketing materials, including incorporating similar color schemes. Yeah, that's what I said. Maybe similar color schemes. along with design elements, a Ferris wheel and silhouettes of palm trees and the mountains surrounding the Coachella Valley. Shown below are representative examples of plaintiff's promotional material on the left and 29 palms on the right. So these are another comparison. I don't think they are picking the best. Oh, maybe because the Ferris wheel. I guess that one. But I'm like, the colors, on the other hand, I don't know if I would say this is the same color scheme. But again, I am not an artist. So I don't know if I can make the best comparison as far as color scheme goes when I do not do art. So making it a little bit bigger for you guys. These are the different ones. Okay, I see the Ferris wheel. Coachella is well known for having that Ferris wheel. The palm trees, same thing. They're having it in Southern California in a similar area. Is it kind of unfair business competition? Maybe. They also reflect that it's a concert by showing people singing and guitars and drums and all the things, which looks a little bit more, to me, looks a little bit more lit than this one. This one looks like we're going to the beach. Coachella's look like we're going to the beach, or in the desert, like they say, 20 years in the desert. But this one looks like we're about to party, okay? We're about to party. But I can see why they are saying this is confusingly similar. Okay, moving on to more information here. We have, in fact, on or around December 9, 2021, 29 Palms began offering complimentary tickets to Coachella Day 1, 2022, or I keep saying 2022. It's just 2022. Which are listed on Ticketmaster as Coachella complimentary offer. Okay, that's doing the most. The Coachella complimentary offer, they're not even trying to distinguish it at this point. They're probably making people think that Coachella is having something in the dead of winter for New Year's Eve and that this is associated with them. I see why they're suing. I absolutely see why they're suing. Okay. And then we have, despite having no actual affiliation with Plaintiff's Festival, the offer, which is available on Ticketmaster website as shown below, they go ahead and show us the ticket. It says day 122. Oh, I get it, because it's New Year's Eve. So the first day of 2022. Okay. General admission. And down here, you see where it says, let me make it bigger for you guys. It says right under here, Coachella complimentary offer, and it's a free ticket. So yeah. Oh, because Coachella is the city. That would probably be smart to know. I'm not familiar with Coachella like that. So wait, Coachella is the city. I'm trying to think. I guess you can get a trademark for that, but it could be considered geographically descriptive. So they may have an argument there. I didn't know Coachella was a real city. Shows how much I know. Okay. Despite notice of infringement and repeated requests from plaintiffs to exercise their control over the infringement and stop these unlawful acts, Live Nation, through its ticketing segment, Ticketmaster, continues to advertise events at Coachella Crossroads, including Coachella Day 122, and continues to sell tickets to the event, including the new Coachella complimentary offer. I want to look up their trademark now to see if they got a geographical denial. Or maybe the trademark office also didn't know that was the actual city. Possible. Despite notice of the infringement and repeated requests for plaintiffs to exercise their control over the infringement and stop these unlawful acts, Unified Layer continued to host 29 Palms website available at CoachellaCrossroads.com, which advertises live music events at Coachella Crossroads, including Coachella Day 122. Although 29 Palms may have sovereign immunity, because they're Indian tribe, sovereign immunity, other contributing to the infringement do not have the same privilege and are subject to are subject to claims of contributory infringement as well as this court's jurisdiction. Okay, so that's what they keep saying. Oh, you can't sue us because the tribe is not here to help defend us, and they're the ones that did it. That's what's going on here. Okay. Accordingly, plaintiffs have been forced to file this action to protect the Coachella trademarks and service marks from infringement and unfair competition, and to protect the public from likelihood of confusion. Okay, I definitely see why they are suing them. Let me go through some of your chats to see what you guys have to say about it so far. The only thing I would be concerned about, which I'm going to do right now, is look up on the trademark office if they have a geographically. First, let me see. Is Coachella a real city? I don't know. Let's see. Coachella city in California. So it is a city. All right. So now let's go on a trademark search. And we're going to go, I guess I can show y'all this. Trademark search. Let's see what's going on with Coachella. Whoa, that's a lot. It's 100. 100. Let's see. And there's other Coachella Valley Bacon Company. I'm sure that's not the festival. Coachella Best Organic Dates. Coachella Valley Brewing. So I would think that the USPTO does know that Coachella is a city. Coachella Best Organic Medjool Dates. Okay, they got a lot of trademarks. Which ones will be for festival? Can we find it? That one's dead, so that's not it. What is their trademark? Is it this one? Nope, that's jewelry, also known as Coachella. But this one would be conflicting because they're both doing the concert. So I'm trying to find their, maybe it'll tell me the number of what their application is. How about you look at that, Brianna, first? Okay, let's see. Coachella, when they get to bragging about themselves. Coachella. Let me see. Do I see a trademark number here? I don't. I don't see the trademark number. Maybe I'm going through it too fast. I'm sorry, I'm focusing here trying to find this trademark number. But okay, I guess we won't find it there. Usually they will list it. We own trademark registration number, blah, blah, blah. Where is that at? I don't see it. That should be like the first sentence. Okay, whatever. I'm going to see if I can find it here. Let's go to the next one. Oh, even more trademark. Okay, so it's probably one of the newer ones. This one is in class 41, which is probably what we're looking for. Entertainment, namely organizing and producing. Okay, this is one of their trademarks. Here we go. Let's see if they got any rejection here. You can't show me. Okay. I was like, what's going on? Okay. Notice of suit incoming. Somebody suing you already? Okay. Office action outgoing. Let's see here. What did they get denied for? Yeah, it's geographically descriptive. That's what I thought. I'm sorry I had to take y'all on the journey with me, but they got denied for geographically descriptive. And basically what that means is the city is named Coachella and you're having a concert in Coachella. So you're just kind of describing where you're taking place at. Now, they did an office action and they won for whatever reason to make it, we're not going to go through what their arguments were to make it like non-geographically descriptive, but they did get a geographically descriptive refusal initially, which goes to my point of if it's a city and you're just using the city's name, I don't know. I feel like you have a little bit of a tougher time doing that. But the fact that they're so famous, they have a better chance at winning on this. But I did want to fulfill my thoughts that it was probably geographically descriptive. Okay, we have Crystal Harris saying they're only famous to be because of Beyonce. Never noticed them before that. Yeah, I had recently started hearing about Coachella maybe the year or two before Beyonce went there. So she didn't introduce me to it, but I had never heard of Coachella. It must not be in in my community like that. Okay, we have biographer saying, "Hi Bri, happy to be here for the live stream." Well, happy to have you here for the live stream. Nice to have you. Introductions. Deacon Fatal says they can, but it isn't often. Not sure what exactly we're referring to there. It's probably something I said earlier that I forgot about. Deacon Fatal says it's giving me 80s as far as the different promotions go. Yeah. Crystal Harris says they're both using a sunset type picture. That is a good observation. They did use that. Deacon Fatal seconded that. And so those things are similar, but there's a little bit of difference. But like I said, I see why it's confusingly similar, especially it being a music festival and going after that Coachella. The thing is the city is Coachella. That's what's hard about it. The city's name is Coachella. Okay, we have Kath saying, "Hi, Bri, watching you in 2x Vita. Hopefully catch up." Well, I think you can because we've only been live for like 25 minutes, so you should be able to catch up. Okay, Deacon Fatal says, "Oh, comp tickets. Yeah, comp tickets for free to get people to go." Biographer says, "I don't go to music festivals, but I've heard the name Coachella and associated with the music festival. Seems the Coachella Music Festival is the name from the location in the Coachella Valley." Yeah, that's what it looks like it is. And as we can see, there are several trademarks filed. All of them haven't been granted, but there are several of them filed because they probably operate in Coachella and they're trying to distinguish that they're from Coachella. Biographer also says Coachella Valley is the location of the original music festival. And that's why they're suing, because it's also a festival. You're not just calling your new pancakes Coachella and you make them in Coachella, but you're calling literally a festival that is held there every year for what they said 20 years. And then you're also calling yours Coachella Festival, or you're adding some extra words to it and things like that. But they don't want any of that because they don't want that name associated with them. If one, they're making money off your name, and two, if the event goes bad, then they're going to blame Coachella, right? You don't want that. Okay, Dex is the name, says, "I wonder how many USA cities get tangled up in trademarking issues." A lot. That's what I was like, geographically descriptive, off tops. That's the first thing I'm thinking of. But I guess the area and the name, it goes there. Hey, Lee is back in the live stream. Deacon Fatal says, "Yeah, I thought the dispute was with the native people of the land." Yeah, but they can't sue them because of their sovereign immunity, apparently. I'm not too familiar with those laws, so we're learning as we go. Elite also says, "Hey to the BRI-HIVE. Welcome to the live stream." Tanya D said, "Never knew Coachella was an actual city." Me neither. I just thought it was the name of the festival. And I live in California, but I don't live in Southern California. Deacon Fatal says, "Okay, there is a tribe." Yeah, the tribe. They're saying the tribe needs to be there for you guys to sue us for contributory negligence, but they didn't, or not negligence, trademark infringement, but they didn't sue the tribe because apparently they can't sue them. Deacon Fatal says, "And they misspelled the tribe's name." I don't know. I'm lost on that one. I don't know. Deacon Fatal says, "The Coahuila people are the first known inhabitants of Coachella Valley. They have lived in the Coachella Valley and surrounding mountains for over 3,000 years." Oh, good. Fun facts to know. Thank you for the research. Tiny D says, "Of course they spelled it wrong." Says, "I can't." Elaine is smiling, and Craig says, "Hi, Bri, finally got notified of your stream." Yes, finally, YouTube doing the job. Let me not say that too loud because they might stop doing the job. But we're happy to have you here, Anne. They're saying hello to Anne, saying hello back to Tanya. All right, so let's go ahead and check out what they're like. This geographically descriptive. I'm a little bit more on Live Nation's side right now. I don't know. But not all the way, because geographically descriptive does not automatically save you, right? Because they were able to get the trademark for it for music festivals. So Live Nation shouldn't be able to just come in and do whatever the heck they want. Crystal Harris says, singing to myself, they always sue in Southern California. Ishcade Forever says, my mail will go to Texas and I live in Missouri because there is a city of the same name spelled exactly the same way. Oh, really? That's interesting. P says, hi to Bri and hi to chat. Hello and welcome to the live stream. And Tanya says, laughing at Crystal. Okay, so let's go ahead and go on to the motion to dismiss. We are not going to read this whole thing because we got a whole nother case to get to. That case is a little bit shorter, honestly, but we're still going to get to it. And then the motion to dismiss, again, is going to be a little shorter. And it is talking about the tribe. It's going to talk a little bit about the tribe. So we might go ahead and look into those arguments, because they filed several motions to dismiss saying that the tribe was not a indispensable party and they need to be here in order for us to defend our rights, right? Okay. So let's go ahead and pop over here to, this is the motion to dismiss filed by the defendants, basically saying you shouldn't be suing us because of these reasons. So we have defendants Live Nation Entertainment Incorporated memorandum of points and authorities in support of its motion to dismiss under Civil Procedure Rule 12B7, indispensable party. Okay. They are going to go on and give us this table of content. I forgot what it was called. The interest, one of the reasons why they're arguing is that the tribe claims will be impaired. So who's not in the lawsuit, it will be impaired. And so we can go through that information. They also go through, there's a conflict of interest created by the tribe's indemnification. Basically, they went ahead and did all of this trademark infringement and then left us people that could be sued out here out to dry. As a conflict of interest because they're putting it out the way that they need to put it out in order to get people to come in. But now Live Nation and the other defendants are left being the ones sued here. And then it goes over the standard to review, and the tribe is a required party. We'll look into that. Live Nation cannot adequately represent the tribe's interests. Well, we could probably look into all of this, honestly. And then 19B, factors in favor of dismissal. We probably won't look at that because that's just going to be technical junk that we don't want to consider. Well, that I don't want to consider, right? Okay. They go ahead and have an introduction. Then we go into the facts relevant, the court's decisions, and then the tribe's interest. So let's go ahead and look at the tribe's interest real quick and see what's going on. Okay, so the tribe's interest in its coexistence agreement with AEG. We skipped over some stuff. So what is AEG? We'll figure it out. The tribe claims to be a party to a contract with AEG, pursuant to which AEG agreed that it would not object to the tribe's use of Coachella Crossroads as long as the tribe used the mark, did not incorporate any of the Coachella Music Festival logos. AEG also agreed not to object to the 10,000 person concert venue that tribe was planning to build at the time using the Coachella Crossroads mark. Representatives told tribe's representatives that AEG did not see the need to put the oral agreement into writing. So they're basically saying that there was an oral contract here, that the tribe went ahead and used Coachella because someone gave them permission. Probably should go try to find who gave them permission, but I don't want to sort through all these words. Plaintiff's allegation that tribe's use of Coachella Crossroads mark is unauthorized and constitutes trademark infringement contradicts the terms of the oral agreement between AEG and the tribe and the subsequent confirming conduct of both AEG and the tribe per testimony of Ms. Martins and Mr. Mike. The tribe, therefore, has a vested interest in the validity and interpretation of its oral coexistence agreement with plaintiff's parent company, AEG. So apparently AEG is the owner of the Coachella Music Festival. So, oh, sorry, I was reading the chat. Marianne, a member of the channel, says AEG is actually another Live Nation competitor, I think. They're saying that they also own the Coachella Music Festivals as well. So we can probably go look at it afterwards. I just don't want to get lost in all the words in this thing. But what did we learn from the Bishop case where he told the lady he was going to take her $100,000 and buy her a house and renovate it for her with her $100,000 in New Jersey? You need to get your contracts in writing. Don't go off of oral promises that you cannot prove in court. You can only have your testimony, and the jury or the judge gets to decide whether they believe you or not. We see how well that went for Amber Heard. For those of you that watched the Amber Heard and Johnny Depp trial, it didn't go well for her. People didn't believe her. So always get your contracts in writing, especially a coexistence agreement. In order to get your trademark registered by agreement, coexistent agreement, if someone else's trademark conflicts with you, you have to present an agreement to the actual trademark office. You can't just say, oh, no, they agreed to let me have this name too. Like, no, you actually have to present the agreement. There is a fly crawling across the... Good job. I left the door open and these flies are just not dying. Okay. He really just it really just crawled on the camera lens. That looked weird. Okay. Let's go over to the rest of this. Back to the case before the fly interrupts again. Subsidiary, where we at? The tribe's interest in the contract with Live Nation subsidiary Ticketmaster LLC. The tribe and Live Nation subsidiary Ticketmaster LLC have an agreement in which Ticketmaster is the exclusive ticket seller for events held by the tribe at the Coachella Crossroads venue for 5 years, including the Coachella Crossroads venue. Plaintiff seeks an order requiring Ticketmaster as a Live Nation subsidiary to cease all sales of tickets for events at Coachella Crossroads. If Ticketmaster is enjoined from selling tickets to Coachella Crossroads events, the tribe will be unable to enjoy the bargain for benefit of this agreement. They also say the tribe's interest in the sovereignty. The tribe claims an interest in sovereignty, having established various business enterprises and governmental operations on its sovereign lands. This lawsuit threatens the tribe's sovereign interests. As Mr. Mike explains in his declaration, the tribe has agreed to indemnification terms with Ticketmaster, under which the tribe could potentially be responsible for indemnifying Live Nation for third-party claims arising from the tribe's infringement of another's trademark and or other intellectual property. Accordingly, the tribe may be exposed to financial harm in the event that Live Nation does not prevail in this lawsuit. In other words, the lawsuit is effectively an end run around sovereign immunity to which the tribe is entitled by long-standing precedent. Yeah, you can't agree to indemnify someone and then be like, oh, wait, no, I can't indemnify you because I have sovereign immunity. That's messed up. Okay, the tribe's ownership interest in Coachella Crossroad Mark. The tribe claims the right to the name its venue Coachella Crossroads and to hold events under that name. The tribe also claims rights to the ownership of the mark Coachella Crossroads, which is that the right to license to others. By their complaint, plaintiff seeks to enjoin defendants and all persons acting in concert with or in conspiracy with or affiliated with defendants or the tribe from using Coachella Crossroads mark. This broad request relief would have a dramatic impact on the tribe's interest in the mark that reflects the tribe's long history in Coachella Valley, a history that predates plaintiff's generations. I think that was the information that Deacon Fatal gave us, that this tribe has been there for 3,000 years, and then here comes Coachella 30 years later, or 30 years ago, saying, oh no, we own everything Coachella. The tribe is like, no, and you can't sue me about it. We own Coachella. And Live Nation is like, no, well, if they own Coachella, then we should be okay. Moreover, plaintiff's requested injunction is extraordinarily broad and effectively seeks to block any individual or company from working with the tribe as long as the tribe continues to use the name Coachella Crossroads. I agree with that. Such an order would have a direct impact on the tribe's business, including the third-party vendors and clients. Mr. Mike explains in his declaration that plaintiff's threats to date have already caused a number of vendors to cease doing business with the tribe. As just one example, Mr. Mike testifies that the tribe is a multi-year agreement with the billboard company plaintiffs sought to shoehorn into the lawsuit in their ex parte application to modify the court's original restraining order. If the court were to issue injunctive relief plaintiff has requested, the tribe would lose their bargain for benefit in yet another contractual relationship. So their argument is basically that the tribe can't be sued, so you can't sue us either, because the tribe is the one responsible for this trademark, the Coachella Crossroad trademark. So I see their argument. I see why they're saying that's not fair. I still think they're going to have to pay them something. So it's basically just saying about how the tribe has all of this all of these rights, right? So let's go ahead and take a look at the arguments, saying that the tribe is a required party and therefore this case needs to be dismissed because they failed to include this indispensable party, meaning a party that we cannot proceed with this lawsuit without having. An absent party claim is protected interest is sufficient under Rule 19 so long as it is not patently frivolous. Here, the tribe has claimed at least 5 non-frivolous interests that may be impaired by the continuation of this action, none of which were before the court when it considered the issue in the temporary restraining order. Each interest the tribe claims is independently sufficient to render the tribe a required party now. First, the tribe claims to be a party to a coexistence agreement with AEG. The Ninth Circuit has repeatedly upheld that all parties to a contract are necessary in litigation to decimate that contract. It goes through more rules that we're not going to read. There is no question that plaintiff will attempt to decimate or set aside the coexistence agreement, as consent is a complete defense to trademark infringement. Prohibiting use without the consent of the registrant, at least plaintiff will attempt to litigate the scope of the agreement and the intention of the parties. District courts in the circuit facing similar facts, including intellectual property cases, have found absent contractual parties require. So since they're claiming this oral contract, they're basically saying that the tribe needs to be there. Second reason the tribe is an indispensable party. The tribe claims a significant interest in a 5-year contract with Ticketmaster that may be impaired if the court enjoins Live Nation subsidiaries from selling tickets to the event at the Coachella Crossroad venue. That would be a problem because they have a contract with the tribe and the tribe cannot be sued. And then we have a third, the tribe's interest in its own sovereignty may be impaired if the court were to enter a monetary judgment against Live Nation, essentially due to the tribe's indemnity agreement with Ticketmaster. A monetary judgment against Live Nation could operate as an indirect monetary judgment against tribe, which would offend the purpose of the sovereign immunity. So they wouldn't be able to defend themselves in the lawsuit. The tribe would not be able to defend themselves in the lawsuit, yet they're still going to have to pay for the lawsuit because they have to indemnify Live Nation if Live Nation loses. And basically indemnification just means I have to pay you back. So I've signed a contract saying if you get sued, I am responsible for paying your fees if you lose. So that's basically what the indemnification is. Fourth, the tribe's interest in its claimed Coachella Crossroad marks may be impaired by a ruling that the mark infringes on plaintiff's marks, which makes sense. They're the ones using the mark, so they should have an opportunity to fight against whatever Coachella Music Festival is saying. The tribe's Fifth, the tribe's cultural and historical interest in referring to its property in Coachella, California, protected by the First Amendment, may be impaired by an injunction that would effectively prohibit the tribe from conducting business with anyone while referring to its Coachella Crossroad venue and otherwise using the word Coachella in connection with the activities occurring in the tribal land in Coachella, California. All right, so those are all the arguments that they are making as far as the tribe needs to be in this. And the thing is, they can't sue the tribe. From my understanding, like I said, I'm not too familiar with the tribal rights and things like that, especially even when it comes to trademark. I've never dealt with that, so I'm not too familiar with it. But what it sounds like is that they can't sue the tribe, so they're trying to sue the tribe's business partners, but that the tribe will then be responsible for paying the business partners back if the business partners do lose the case. So interesting stuff. So let's see what the chat is saying. Oh, I just see my flowers in the back looking so sad and dead. Oh. Okay, where were we at? Here. Okay, we have Julie saying Live Nation thinks it's so big they are untouchable. Well, they keep getting sued, so it sounds like they are touchable here. Say hi to Julie. Deacon Fatal saying oral contract. Yes, another oral contract. Not a good idea. Julie says everyone is so sweet. Same mindset as Emily D. Baker. Love it. Yes, the BRI-HIVE is nice and fun over here as well. I think a lot of the communities cross over, so we like to keep the people that we vibe with here. So I am happy that you are enjoying the community so far. Marianne Williams says AEG is actually another Live Nation competitor, I think. Okay, I think I read that one earlier. Deacon Fatal says, nah, that's not good. Oral contracts aren't a thing. Not in business. Maybe with your little sister, when you agree to give her like some chips, if she goes get the remote for you, maybe. But in business where you're making thousands and millions of dollars, no oral contracts. Kat says, oh, wow, I did catch up. Yeah, exactly. We weren't too deep in when you said that. Deacon Fatal says that oral contracts don't exist. Yeah, we covered that one. Hi, Fly. Yeah, the fly was all up in the camera. Deacon Fatal says, oh, ain't Ticketmaster going through some mess too? Well, they will be. I'm not surprised if they are. All these big companies are always getting sued. Rose says, the fly said it's my stream not now. It really did. And then now it's just like flying around and it just won't leave this room. I don't know why. It could go like in the kitchen or something. It might find a snack in there. But in here, I'm just like, why are you here? Maybe because the flies don't like flowers like that, huh? I don't know. Crystal Harris says, if it's a fruit fly, just set out a cup / bowl of apple cider vinegar with a little bit of dish soap, and you don't have to cover it. They don't care, but it really works. Kill the fly. Is that what we're suggesting? And they say it's a big fly. It's really not a big fly. It's a small one, but the type of lens that I have on my camera, it just zoomed into it. So it seems like it's big, but it's really a small or normal size fly, in my opinion. Okay. Cap says, I don't know if it's a dumb question, but can they get something for similar marketing material if they can't claim anything for the festival name? Or do you get dismissed altogether? Does it make sense? Yes. So the other thing that they are suing for is unfair business practices, which is it kind of covers, okay, Coachella markets in this way. They put up these type of posters using these color schemes, and that draws people to their aesthetic, right? So the unfair business practice is part of that, and they did sue them for that, if I'm not mistaken. I think, but again, it's contributory, which their argument is that the tribe needs to be involved in this in order for it to be, contributory. Yep. So they did go ahead and sue for unfair competition. So yes, you can. And they did. Deacon Fatal says, well, then if you know the tribe cannot be sued, why play there? I did not get their response to this, to tell you the truth. And I don't really have time to get it right now and go over what Coachella's argument is regarding that. So I really don't know. I honestly don't know. Deacon Fatal says, what would be the cool thing to study though? Yeah, it would be cool to look it up. I'm just not too familiar with how the tribe protection applies to trademark law or to any law, really. They have a lot of protection with that sovereign immunity. Deacon Fatal says, we have been talking a mess in this chat. Just give your flowers some water. They will wake right back up. I did. And they just died even faster. And I got these on Sunday, like Sunday evening. And they were dead by like Monday or Tuesday. It was ridiculous. I don't know what to do. I put water in it. The pink flowers are fine, but the sunflowers, the part of the BRI-HIVE, is not fine. They're very sad here. Maybe I need more sun or something. Cheryl Reed says, hello, Bri and BRI-HIVE. Happy to be here with everyone. We're happy to have you joining our Coachella Festival over here. Deacon Fiddle says, the fly is happy there. The fly is happy here. Having a great time while I'm trying to stream. Yeah, but look at my little flowers. They're so sad. So sad. But they died really fast. So I don't know what to do. I'm not a plant mom, so that could explain a lot of the situation. Okay, so we got through all the chats regarding that right there. And so now we can move over to the next case. Go ahead and drop in the chat whether you heard of this case. Again, for the people that might have missed the beginning, or if you forgot, the next case that we are covering is the Timberland and Swiss Beat suing Triller, which is a social media company that they apparently sold their Versus company to, and they're not paying them. So another lawsuit, another day, another lawsuit. That's what I like to say. And it honestly, it was filed on the 16th. So this is a brand new case. We're jumping right into it. And hopefully they expose their contract. I would love to see their contract. So let's go ahead and check out what they got going on over here. I'm hoping y'all cannot hear that garage sound because it's loud. All right. So this is a case filed in the Superior Court of California in the County of Los Angeles Central District. And we have Timothy Mosley, also known as Timberland, the producer. And then we have Kasim Daoud Dean, also known as Swiss Beat, suing Triller Holding Company, LLC, a Delaware limited liability company, and Triller Inc., a Delaware corporation. And for those of you who do not know what Triller is, we are in the same boat. But to my understanding, it's a social media app where people dance to music and do these trends and things like that. Just like TikTok is supposed to be a competitor for TikTok. If you don't know what TikTok is, I don't know what to tell you. It's a social media app where you just voice over or dance and whatever the young kids are doing, right? So that is what we're talking about here. And they are suing them for breach of contract. Breach of contract because you did not pay me, right? Okay, let's see what they are alleging. We're not going to go through the parties or the venue. I don't like covering that on my channel. Okay, so let's go ahead and get into it. Plaintiff Mosley, which is Timberland, and Dean, who is Swiss Beats. On the other hand, the defendant... Oh, that was a weird sentence. Plaintiff Mosley and Dean on the other hand, and defendant Triller on the other. I don't know why they put the sentence like that. That really just distracted me. Okay. Defendant Triller Hold on the other executed a certain unit purchase and contribution agreement as of January 27, 2021, pursuant to which defendant Triller Holding Company agreed to purchase equity interest in Versus LLC from Moses and Dean pursuant to the terms and conditions of such agreement. As a material inducement for Mosley and Dean to enter into the unit purchase and contribution agreement, defendant Triller executed that agreement by which it unequivocally, okay, and unconditionally guaranteed to Mosley and Dean the payment and performance of Triller Hold's obligation under the agreement and related agreements. Pursuant to the unit purchase and contribution agreement, certain payments were to be made by plaintiff Mosley and Dean on or shortly after the closing date, and other payments were to be made on the first and second anniversary of the closing date. In accordance with the unit price and contribution agreement, defendant Triller Hold made the first two payments to plaintiff Mosley Dean in January 2021 and April 2021, respectively. On or about January 28, 2022, so the next payment is coming up, defendants defaulted under the terms of the unit price agreement and contribution agreement and failed after receipt of written notice of default to cure the default. All sums under such agreement were accelerated and immediately due and payable to Mosley and Dean. So they basically started the contract by paying them the first year, and then the second year rolls around and they didn't pay them. We're going to go through the provision where they're saying if you don't cure the defect, which means if you don't pay me in time of what in their contract 5 days after we let you know, like, hey, you forgot to pay me, then we're going to sue you, or then the amount is due immediately. So you don't get the little payment plan we had set up originally. Okay. Thereafter, on or about February 25th, 2022, defendant on one hand and Mosley and Dean on the other. Why do they use that type of language? Enter into a certain settlement and payment agreement pursuant to which the parties agreed to settle and compromise the accelerated sums due and owing from defendants upon the terms and conditions set forth in the agreement. A true and correct copy of the agreement is attached. Ooh, did I have access to that? I don't know. I don't think it was available yet. Well, at least not for free. Subsequent, oh no, this one is in LA County, so we're going to have to pay for it. Yep, we're going to have to pay for it. Subsequently, in February 2022, defendant made the first payment to Mosley and Dean in accordance with the new agreement. So what this is basically saying is, okay, they defaulted, they didn't pay on time. So all of the money was due immediately. But then they entered into a second agreement where they said, okay, you don't have to pay us everything right now. We'll set up a new payment plan. And what they're saying is that they made the first payment under the new payment plan. Triller made the first payment under the new payment plan. Okay. Pursuant to the agreement at Section 1, which agreement? $28 million plus reimbursement of certain costs and expenses remain due and owing to Mosley and Dean pursuant to the payment schedule set forth in the agreement. Specifically, the agreement provides that remaining payment must be made to defendants as follows. Triller shall make a payment of $18 million, $9 million to each Timberland and Swiss Beats upon the earlier of 3 business days following the closing of not less than $100 million pursuant either individually or in aggregate, pursuant to a subscription agreement dated February 14, 2022, or the closing of any other investment for Triller Securities, or March 17, 2022, the payment obligation is unconditional regardless of the fact that the minimum funding may not have been achieved. Such amount shall be reduced to $17 million, which will be $8,500,000 to each of the Timberland and Swiss Beats. If the payment contemplated by the last sentence of Section 1A has been made. So they want their money, and they set up a payment plan for them, and they have to pay it whether they were able to obtain more funding or not. Starting April 1 or March 1, if the minimum funding has been achieved in February, Triller will make a payment of $1 million, which is $500,000 for each Timberland and Swiss Beats by the first day of each consecutive month for 10 months. If during that time Triller receives an additional $100 million of funding, all remaining payments will be accelerated to 3 days after receipt of Triller of the funds. Similarly, all remaining payments shall also be accelerated to 5 business days after the closing of Triller's merger with Sea Change. So that's a lot of words. Basically, they can start on a payment plan of $1 million a month for $10 million in order to pay off their debt. Or what they can do is when Triller receives this $100 million that they're allegedly about to receive, once they receive that, then all of the money will be due immediately. So they're trying to give them a little bit of wiggle room to make sure they make enough money in order to be able to pay them without going into complete debt, right? Triller represents and warrants that it will notify versus members by email to, they did that on the day, they redacted the email, sorry, on the day it receives minimum funding. Cost and fees, Triller shall reimburse versus members, which will be Timberland and Swiss Beats, their reasonable attorney's fees, which is $85,000. I wish I could charge $85,000 for Timberland and $35,000 for Dean. I didn't even finish reading it. So this cost them $120,000 altogether for probably like 2 months of work. That's a lot of money to pay lawyers. Those lawyers are living happy lives, like Tom Girardi. Incurred to the date in connection with milestone payments and this agreement. So drafting up that agreement for them to pay them back their millions cost them $100,000. This is hurting my soul. That's so much money for a contract. I am not a high dollar attorney, I'll tell you that. For a contract. I wonder how long this you know what? It's attached as an amendment and I might have to buy it. Or maybe I don't have to buy it. I might just go on LA County and see how many pages is attached to this thing and let me know how many pages did they write that cost them $120,000. That's a lot of money. That's so much money. That's my whole year's salary that I'm trying to earn, man. Okay, let's back to the context of the actual case. It's a whole year's of work. Do you understand that? Okay. For one client. Retainer is probably like 50. The retainer actually probably like $1 million. Who is? I gotta look up this law firm after this. Okay. Let me try to get back on track. Such reimbursement shall be made by wire transfer as follows: $20,000 of Mosley's attorney fees shall be paid within 3 business days after the execution of this agreement, and the remainder of all such fees shall be paid concurrently with the payment set forth above. Defendant defaulted under the agreement by failing to make a payment of $18 million by March 17, 2022, as required by Section 1B of the agreement. Why would they sign this agreement knowing they didn't have the money to pay this? Okay, let's go with it. Defendants also defaulted under the agreement by their failure to pay the sum of $95,000 by March 17, 2022, as set forth in Section 1E 2Is. Also, defendants defaulted under agreement by failing to make the payment of $1 million, $500,000 to each Mosley and Dean on April 1st, May 1st, June 1st, July 1st, and August 1st, 2022. Oh, they are not paying. So they are now, what would that be? 18 million plus 1, 2, 3, 4, 5 months, which at 1 million each, 18 million plus 5, 23 million. They're 23 million in debt plus the $120,000 that they owed in attorney's fees. The agreement further provides in Section 3 that an action for breach of this agreement, if Triller breaches any payment obligation under this agreement and fails to cure within 5 days after receiving written notice of such breach, the full unpaid amount remaining due under this agreement shall become accelerated and be deemed immediately due and payable. And with respect to such breach, Triller hereby permanently waives and releases all claims and defenses of each and every nature, both legally and equitably waived and released claims and defenses, except that timely payment was in fact made by Triller. Now, that may be considered unconscionable. I don't know if I don't think the court will let them say, hey, if we fail to pay you, we can't raise any defenses. That seems a little bit unconscionable to me, which basically is just a fancy word for unfair, to shock the conscience of a reasonable person, right? On April 8, 2022, Mosley, which is Timberland and Swiss Beats, through counsel, provided written notice of default to defendants and further advised that if the past due payment of $19,095,000, and that's divided by the $18,095,000 that was due on March 7th, and then the $1 million that was due on April 1st, was not received within 5 days of receipt of notice, then the remaining balance of the payments due under Section 1C of the agreement, $9 million, shall be accelerated and immediately due and payable. So $28 million, they want you to pay it right now. Well, let me tell you something. If they did not pay the $18 million, what makes you think that they have $28 million? You're not getting that money. And that's why we are here in this lawsuit right now, because they don't have it. They don't got it. You're not getting that money. And then you're going to sue them. And then there may be a settlement, or you may go to trial. And let's say you win, right? You win, right? Because they clearly didn't pay under the contract that you done sold them the company. Okay, that's fine. But you get a judgment. And they still don't have no money, because now they done paid their lawyers to try to defend themselves. And then you're going to put them on another payment plan. Their company is just going to go down the drain, and you're never going to get this money. So you're spending hundreds of thousands of dollars on attorney's fees because you've already spent $120,000 before you even made it to court, just telling them to pay you, an agreement and sending out letters for them to pay you. I just don't. What are they billing at? What are they billing at for that? $95,000 in attorney's fees? They got to be billing at like $5,000, $10,000 an hour. That's ridiculous. And I'm not even going to put them on blast like that. They might already have that contract. Y'all are not getting paid. Y'all are just doing this for not the fun of it, but to basically prove your point. Because if they didn't have the $18 million in March, they don't have the $18 million now. Maybe the platform will blow up and they'll make that much money, but them getting sued, I'm pretty sure investors are probably gonna pull out. But let's give them the benefit of the doubt. That's a lot of money. It's a lot of money. Okay, let's go. Defendants have failed and refused to respond. Now they're not answering their phone. Defendants have failed and refused to respond to plaintiff's written notice and demand for payment. To date, defendant have failed and refused to make any payment to Timberland and Swiss Beats. The past due sums due and owing, and defendants continue in default of their payment obligations under the agreement. The aforesaid default constitute material breach, which is true, of the agreement by defendants. By reason of defendants continuing uncured defaults, the sum of $28,095,000 is immediately due to be paid under the agreement. Again, you are not getting that money unless this platform blows up. Defendants have no defense to this action and have, pursuant Section 3 of the agreement, permanently waived and released all claims and defenses of each and every nature, both legally and equitably, except that timely payment was in fact made. Again, I think that would be held to be unconscionable. As a direct and proximate result of defendants' breaches of the agreement, plaintiffs Mosley and Dean have suffered damages, and there is presently due and owing from defendants to Mosley and Dean under the terms of the agreement of $28 million. They keep saying this, $28,095,000 plus costs and applicable interest. I don't know where they're getting maybe they must have paid the 95. They must have paid the 25,000. That's what I'm thinking, because it should be 28,120,000 if I did my math right, which I think I did. Okay. Section 3 of the agreement provides a pertinent part. In any lawsuit between the parties regarding said breach and acceleration, the prevailing party shall be awarded its reasonable attorney's fees plus the $120,000 you've already incurred. Oh, this complaint is 6 pages. It probably costs like another $100,000. Okay. Because they needed to do the research and read the contracts, even though they're probably the ones that wrote the contract, or that they already reviewed the contracts to prepare the other agreement. Okay. Triller represents and warrants that it will not interpose any waived or released claims and defenses other than that timely payment was made. By reason of the foregoing, plaintiff Mosley and Dean are entitled to such reasonable attorney's fees costs. People are brutal. Famous people are brutal. That's insane. They're going to make you sign a contract that says, if you don't pay us, you can't raise any defenses. Okay. I don't know how well that's going to hold up in court, but okay. That's probably why Triller went ahead and signed it. Okay. All right. We're going to go into like the prayer for relief of everything they're asking for, which is obviously their $28 million. Oh, okay. All right. And we have Susan dropping a super sticker. We can't see what it is on StreamYard, but it is a little, I think it's a fox doing thumbs up saying good job. Well, thank you for the super sticker. I definitely appreciate the support of the channel. We are happy. Yes, super stickers. So thank you so much, Susan, for sharing with us and supporting the channel. All right, so let's go back to the prayer of relief. I'm sorry, I'm in shock. I'm just in shock. All right. They are asking for compensatory damages in the amount of $28,095,000 plus applicable interest on the sum of $18,095,000 from March 17 and the sum of $1 million from April 1st, 2022. And the sum of $9 million from April 14, 2022. For cost of the suit, including all reasonable attorney's fees, in addition to all costs, expenses, and attorney's fees incurred in enforcement of the agreement as may be determined by the court, is $95,000 to send a letter and draft up a contract, maybe go through some negotiations. Is that reasonable attorney's fees? Those are questions that need answers. It could very much well be for people of their stature, like they're famous producers making all this money. So that may be reasonable attorney's fees. I don't think that famous people have to get budget lawyers like me if they want to recover all their attorney's fees, right? They also want prejudgment interest in accordance with the law and any further relief the court deems just and necessary. What do you guys have to say about this? This is making me crack up, to tell you the truth. Who is this? This is from Sing Sing Trobin LLP, Thomas Richards. I want to look them up. Sing Sing. How do you spell that? Sing. I want to see what this website look like, because they are charging a lot of money. Okay, let's look at the website. I'll make me little for this. This is Sing. Featured. Oh, you guys, it's all men. All of their attorneys are men. Oh, okay. They cover entertainment law, corporate law, intellectual property, and litigation. And they're charging that much money. So these are the partners. Sing. They don't look related to me. I wonder if they're related, but they both have the same last name. And then a partner here, which is Trobin. Another partner, Richards. Another partner. Really? This is y'all team. Whatever. That's fine. But this is the lawyers that are charging that much money. That's a lot of goddamn money. They are in Beverly Hills, so I guess they're considered a boutique entertainment law firm. This is not $95,000 is not boutique, if you ask me. Okay. Let's see what you guys have to say about what is going on in this case. Let's see where we're at. We have Crystal Harrison. I heard something about Sprite or carbonated water helps plants since it has oxygen. Oh, I never heard of that. That may help. Tiny D says they bought it for the versus battles. Oh, I didn't know. I'm not all the way familiar with it, but thank you for the information letting us know. We have Data for Insight saying, hi, BRI-HIVE. Hello. We actually covered the case that you requested on Tuesday about the, I forgot already because this case has hyped me up. What case did we cover before this? The Coachella case. Yeah, we covered the Coachella case. So if you missed the beginning, make sure to go back and watch it. We have Cheryl Reed saying, does it state how much money overall? So what's owed overall is $28,095,000. And then he said question answered. Okay, I didn't see that. Tanya D says goals, Bri, goals. As far as charging a whole year's salary for two, I don't know exactly how much they did, but from what I've seen, it was 2 activities. Like I said, maybe some negotiations, maybe some I'm sorry, I just saw the $140,000 settlement here. But I'm looking at their website still. Where am I at? Negotiations, the contract for the repayment plan, the sending out letters for it to get paid, maybe some negotiations, maybe some phone calls, maybe some emails, maybe some paralegals doing some work. $95,000 over the course of 2 months, 3 months. I don't know. I don't charge that much, so maybe that's why. Maybe that's why I don't understand it. But yes, goals in life, right? Crystal saying that's good. 4 years of work for everyone else. Exactly. That's a lot of money to be charging one client. Ridiculous. Feel like this is like Power, and they want that $1 million retainer to defend Tyreek. Anthony Curtis, welcome to the live stream, saying hello from Houston, Bri. Keep going on and do not stop. Very interesting week. My doctors say I'm doing well so far in health issues. Well, I'm glad you are doing well, and I'm glad you're able to join us here on the live stream. We have PNK Faith saying, wasn't Triller sued by H3 last year? Maybe they don't have money. I know there's a lawsuit between them too, or is it Triller for that lawsuit? I don't know. I might be lying. Again, thank you, Susan, for that super sticker. Definitely appreciate you. Cheryl Reed says, how does Triller make its money normally? I'm not really familiar with the platform, to tell you the truth, but if it's similar to TikTok, I'm assuming that they make their money from the ads that they run on the platform. Same thing like YouTube, run ads on the platform. But like I said, I have never been on the platform, so I have no clue, honestly. Maybe sponsors, people who sponsor the company, investors, but at this point, investors are probably pulling out, especially if they are the company that was also sued by H3. Cheryl Reed says, how does Triller make money normally? Okay, that's what we just read. Fat Baby Toodles, love the name always. God, so much money. Yeah, crazy money, crazy amount of money. PNK Faith says, if Triller is going down, maybe they're suing so they're first in line when bankruptcies start, and maybe they'll get some money. Yeah, I agree with that. That's possibly what they're trying to do. But I'm like, how much money are you even going to get out of this if you're already spending that much on lawyers? And I'm telling you that $95,000 or the $120,000, that was just before this complaint has been filed. Imagine how much they have billed since then. Crazy. But it makes sense to get in line for the bankruptcy for sure. Deacon Fatal says, which makes me think I need to become a good entertainment lawyer, right? That's what I wanted to do originally, and maybe I need to call up Sing Sing and Trobin and see if they need a lady lawyer on their team, because they don't have any. They don't have any women on their team. Maybe the paralegals are women, but no women lawyers, no black lady lawyers. So maybe they would be interested. I don't know. Rebecca H says, I have to wonder if Tim and Swiss are angling to get versus back. That could be am I saying that right? Versus that could be. I don't see why not. Because the thing is, they are getting paid for giving them that, so they could potentially just get it back and then I guess go sell it to someone else. That may be part of the settlement. Deacon Fatal says why they are trying to ghost versus. I don't know. Rebecca says ever since they sold Triller, there's been noticeable issues with the shows and ton of viewer complaints. Yeah, that can happen, especially when you change management. Sometimes you need to get rid of the management that you have, but other times you need to change management, right? And then sometimes the new management does just as bad or worse than the other company. All right. Deacon Fatal says they aren't getting that money back. I don't see it happening. They can wait for it though. They can for sure wait for it. They might be better off just taking the company back under their hands. Deacon Fatal says, okay, word on the music street is no one cares about verses and are upset that they sold out to Triller. They are more like this is what you get for selling out. That could be a reason too, right? That's their fault though. They were trying to make money rather than like running the platform, right? Deacon Fatal says that's just Twitter though. The word on the street, Twitter. The Upside Down, welcome to the live stream. We have Deacon Fatal, Rebecca H saying Deacon, that's why Tim and Swiss are trying to get it back. It was far better before they sold it. I think that could be a reasonable reason, to tell you the truth, guys. Boring Cheese, what a name, saying, I feel like people are just writing big money numbers as much as possible because it's fun. Yeah. Are you going to get paid that? Well, this firm has probably already been paid that because they're dealing with a millionaire. I could probably look up how much their net worth is. They're dealing with these millionaires. They probably already paid them, but it's Timberland and Swiss Beats going to be trying to get their money back because they don't want to have to pay money to get their money. But yeah, these people, they look pretty happy. These lawyers, I just can't get over it. They look real happy. I would be happy too if I could charge one client $100,000. Susan Silver says, found you on Emily D. Baker and wish you the best. Thank you so much. Thank you so much. I'm happy that you came over and I hope you are enjoying the live stream. Deacon Fatal says to Rebecca, from Nas, I would have never sold verses in the first place. Now they have to get on their knees to get paid. Yep, that's what's happening right now. Jane Studart says, Bri, you are worth that to us. Thank you. Thank you. I'm hoping it translates into like YouTube money or client money or something. But yeah, that's a lot. And I'm happy to be here. This is fun. Live reactions to the crazy things that go on the cases is much better. I don't know if it's much better than getting $100,000 in one day, but it's a great time. How about we say that? Upside Down says, LOL, Beverly Hills is all I had to see for their charges. Yeah, exactly. We have Z Seltzer with a super sticker. Thank you so much for supporting the channel. I got to scroll up on the YouTube to see what it is. It's a little lemon with heart eyes just kind of dancing around because StreamYard doesn't show us the stickers. But thank you so much for supporting the channel. I definitely appreciate it. And we have Rebecca H saying boutique equals expensive. That is a fancy word. Usually when they say boutique, it's just like, oh, it's a small little firm. Like I would call my firm boutique, but they're like boutique equals money in Beverly Hills. Okay, Julie says, your laughter is fun. I'm working and laughing along. Oh, thank you so much. I'm happy that you're able to laugh while you work. These people here, they probably laugh while they work too. Look how happy they look. Look how happy they look. And then this guy here, he has some fun glasses going on. What a great place to work. They look absolutely happy. Let me stop hating on them. Rebecca says to Deacon, that's the opinion of a lot of people. I remember the comments when they said they were selling it, people were mad. And now they got to chase their money, which is crazy, right? Dav's Beat says, if Triller is getting a cash influx of 100 mil, I don't see them chucking 30% of that to Tim and Swiss. That's if they get it, though, because that was supposed to be some investment money that they clearly have not. Well, maybe they did get it and they're just not paying them. And Timberland and Swiss Beats does not know that they have it. But my assumption here, if we are correct in the chat saying Triller is the one being sued by H3 and now they're being sued by Timberland and Swiss Beats, I'm going to assume that they didn't get that $100 million. I don't see people wanting to invest in a company that's being sued left and right. You can barely keep up your corporation status in California if you're going to sue that much. Okay, Deacon Fatal says Versus isn't as big as TikTok. Yeah, I've never been on the platform. I don't even know what it's about. Kimmy Locker says Triller and H3 have several lawsuits, but Triller and or its owner CEO, I can't remember, was the plaintiff. Okay, so Triller was the one suing H3. I think, hasn't Emily covered that case? I feel like she did because that's why it sounds familiar to me. Deacon Fatal says, and isn't it also a link with Instagram, which is also in link with Facebook, who might also be about to lose money? I don't know. I don't know the answer to that. Kimmy Lockett says, I just joined. Who sued Triller? Timberland and Swiss Beats, producers in the rap and R&B industry. They are suing, and apparently they sold it to Triller. Okay. Fat Baby Toodles, this name makes me laugh, says, wait, so Triller is just a platform? LOL, I'm so dumb. I thought it was a he and it was maybe a rapper. Good stuff. Yeah, I wouldn't have known. I just seen the headline and got into it. Like I said, I've never been on the platform either, and I don't know what the platform is about. I just read some articles and they told me it was like TikTok. So I'm going with that it's like TikTok until I can see it for myself. Deacon Fatal says, if you do, I will need a lawyer to become the entertainment. Okay, I won't charge you $100,000. Unless I do adequate work. $100,000. That's like, if let's say for whatever reason they are charging $1,000 per hour. They did 100 hours of work. In my opinion, I highly doubt that. To draft that contract, I mean, I guess if you're having like one partner write it, another partner, no, let's not even go there. Let's say an associate writes it, the paralegal reviews it, the associate then reviews it again, then they pass it up to the managing partner, then they pass it over to another partner. Then maybe I can see how you get to $100,000, but 100 hours of work on, let's say you're charging $1,000 an hour, I'm just not seeing that much work go into that kind of contract. And like I said, I would love to see how long the contract is, but with a payment plan, I'm thinking that the contract is not that long. So interesting stuff here. Got some combos going on. Rebecca says to Deacon, that's Teddy Riley Wi-Fi. Okay, let's see. We have Crystal Harris saying, in the South, the boutique is another name for the thrift store. Well, they're not charging thrift store prices for sure. Rebecca says, it was absolutely a hot mess. I'd love to see them do it again the right way. I'm not sure exactly what you're talking about there. Kimmy says they laugh all the way to the bank. Yeah, they're happy. They are happy individuals. Deacon says, please stop. Deacon Fatal says, here is the thing. I don't even know how Triller is. Me neither. Or who Triller is. I don't even know who it is. Who is that said they thought it was a rapper? Upside Down says, Bri, don't join them. Create your own firm and give them a run for their money. Ladies, get out your resumes. I have my own firm. I'm just not popular enough. So I need to ride on their coattails, get introduced to Timberland and Swiss Beats and all of these people. They're gonna come after me. Next thing you gonna know, Sing and Chubbin's gonna be suing me. Talking about ride on their coattails. I don't think they're gonna hire me after that one. The internet, right? Okay, that Baby Toodles laughing. Deacon Fatal says, I just learned something new. Kat says Emily D. Baker covered it, but to be honest, my mind was wondering while she was talking. I don't know the deepness into the H3 lawsuit, but I did see her cover it before. I just don't remember because too many things in my brain. Crystal Harris says, watch some rapper coming up going to be named Triller and then they'll get sued. There's probably already rappers named Triller. We're just not paying attention to them. Medea27 says, good day, all from Australia. Made it for the tail end of the stream. Yay, yes, welcome to the live stream. We are just goofing it up over here right now. We covered all of the cases, so hopefully you know what we're talking about at this point. Deacon Fatal says, thank you, because I'm from Alabama and you already know, LOL, but I copyright my stuff though, so I'm not in that much trouble. I'm a low maintenance client. Yeah, that's what I like. I like low maintenance clients. And I have high maintenance clients that I have been working with for more than 3 months, and I have not billed 100 hours on them. I don't bill by the hour anyways, but I have not worked on their case 100 hours, even when they are high maintenance. So them, maybe they charge $5,000 an hour. That's the best I can think of. Maybe I should call them for a consultation. You think they charge for their consultations? I'm over here trying to see if I can get a consultation. They probably charge for their consultations. Dang it. We'll see. I highly doubt they have free their consultation probably like $5,000. Can I interview you guys on my channel to see how much you charge per hour? Okay. Fat Baby Toodle says, thank you, Boss Bri. Love how you're so communicative with us regular folks in the chat. No, I like to hear what the chat has to say. It's fun to me. And we don't have too many people in the chat, so I'm able to kind of look at what you guys are saying. And we're already done with the cases, so definitely like to get the input over from the chat. So when you can join live because I go through the chat for sure. Dabs B says Triller is more like YouTube Red than TikTok. I don't know what YouTube Red is. Deacon Fatal says maybe. Crystal Harris says definitely charging for definitely charging for consultation. Most likely, probably like $5,000. Yeah, they got a lot of stuff over here. I'm all on their website. Okay, yeah, let's look at oh, you guys can see. I didn't know you guys can still see what I was doing. Okay, we got Daddy Yankee over here. They talk about Daddy Yankee a lot. Billboard top music lawyers. I don't know about that. Mel Gibson. Let's say Mel Gibson joins Agent Game Spy Thriller. Okay. Represented. I guess they represent these people. They like to talk about Daddy Yankee. Does that make you a top entertainment lawyer, though? I haven't heard of Daddy Yankee in a long time. Missy Elliott. Okay, that's a little bit high level. Who else do we have here? Selena. No, that's not. You're not representing them. Is Daddy Yankee still popular? I don't know about that. Okay. Deacon Fatal says, hell, I'm trying to get a new lawyer over here. Yeah, I'm not saying don't hire them, but I know I can't afford them. Medea27 says, so if memory serves, the Triller lawsuit was about H3 talking about all of the bad reviews the Triller app was getting. They promised a lot of celebs would move onto it from TikTok, but no one did. I can see that being a thing. I can definitely see that being a thing. There's a couple of apps out there like that. They're like, oh yeah, we're going to be the next big thing. I don't even know. How do you even predict what's going to be the next big thing? But it's not working out, obviously, and they're not even paying their bills. Allegedly. Upside Down says, hello, I would like a consultation on your consultation fees. I can send them an email and say, how much do y'all charge? Fat Boy Toodles says to Das Beats, dang, I feel like geriatric now. WTF is YouTube Red. I have YouTube Premium. IDK what Red is. Yeah, I don't know what that is either. Deacon Fatal says, because entertainment laws are hard to come by in the South, lawyers are hard to come by in the South unless it's in sports. That's true. I went to school in Louisiana and there was like one within a large vicinity. Crystal Harris says, oh no, I can't spell. Sorry, it's okay. Fatboy Toodle says, sorry, that's Pete. Upside Down says, they rep Mel, moving right along. I didn't even see that. Michelle says, oh, I still got it up. Michelle Cancel says, yay. I have to say, hey, I am finally catching you live. I'm normally a replay member since I'm at work when you are streaming. Well, welcome to the live. You are here in the nonsense today because we're just making fun of this company, this law firm, because it's just so ridiculous. How are you charging that much money? And is Daddy Yankee still popular? Does anyone know? Okay. Cheryl Reed says, normally get their high-priced lawyers, but do they win? Or that's questions that need answers. Crystal Harris says Daddy Yankee is his own lawsuit. Allegedly. People on YouTube getting royalties from his song, Shaking My Head. Oh, I didn't know that. Dusby says Red, I think, got turned into premium and it was a music platform. Okay. Paid subscriptions. Okay. For a YouTube Red. PNK Faith says the case I remember is Triller suing H3 for defamation because they said was a bad app and told people to vote for it as they see fit. And H3 won anti-slap. Okay, yeah, that does sound familiar. I think that's what someone said above too. Deacon Fatal says, please hit the like button if you are here. Yes, I forgot. I got too deep into the live stream. But if you guys are here live or on the replay, make sure you hit the thumbs up button and help us out in the algorithm so we can have more fun streams like this. And so that YouTube can pay me some pennies on the dollar because these lawyers are being paid $100,000 for 2 months. Now, let me not say that for whatever work that they have done. So let YouTube pay me. So hit the like button so more people can find the video. Okay. Deacon Fatal says, I haven't heard much of Daddy Yankee. Yeah, me neither. Let me see. You know, I'm nosy. Let's see. Daddy Yankee network. Not that means he's not, popular, but he got 15 million according to Microsoft Bing. Okay. What about Timbaland's net worth? Timbaland net worth. 85 million. So this is a high profile client for them, in my opinion. Let's see. Swiss Beats net worth. 65 million as of 2017. Okay, so they making some money, so they can pay their attorney's fees. But can Triller pay the attorney's fees? Allegedly not, because allegedly they're not paying their bills. Okay. Kimmy Locker says YouTube Red was replaced by Premium and was an all-in-one subscription service that also had YouTube original series. Okay. And then Upside Down says, as of July 2022, YouTube Red was a short-lived paid prescription or subscription service that was similar to Netflix, Disney Plus, and Amazon Prime. Y'all be knowing a lot about what's going on YouTube. I had no clue what that was. All right, guys. So it looks like we have made it through all of the chats. It has been so fun being live with you guys today. I would like to keep up with this case, see where it goes, because I am appalled by the prices that they are charging as a lawyer. And maybe not appalled, but I am just shocked, okay? But thank you guys for joining me live. If you haven't hit the like button already, go ahead and hit the like button. If you're not subscribed already and you made it this far into the video, go ahead and turn your red subscribe to gray subscribe and join the BRI-HIVE. Just join the BRI-HIVE. We also have a membership over on the channel. If you join, it's $5 a month. You get fancy emojis and you get to be a BRI-HIVE member and help contribute to the channel, support the channel. And thank you for everyone that did super chats today. I greatly appreciate everyone that contributes financially. And I also appreciate everyone that contributes with their time and their likes and everything else. So I'm super happy to have the community that I have and super grateful that you guys are supporting me. I will catch you on the next live stream, which will be on Tuesday, and we'll see what other lawsuits pop up over the week.